I haven't read this case. It's first time. I don't know all the facts, but it sounds like just something so insignificant. This person's life went topsy turvy. Probably
It's
get to
crazy.
10 years probably of litigation to get to this point, probably, and thousands of dollars. Whole life is like hanging by a thread. Like, at
It's
a
crazy.
yeah, at a consultation today, and everyone happens once in a while. Is a young guy who came as a baby, left as a baby, then came back in, but there's going to be subject to the permanent bar, and there's no age thing for the permanent bar, so he's stuck with it. So now, like, I had to tell him that. I was just like, I feel like telling somebody you have like some disease or something like that. I want to name some, but it's just like, sorry, you're permanent bar, so you got to leave for 10 years, and it's like that's so disruptive of your life and stuff. It's a mess, and this kind
No,
of stuff to see him go through this.
it's crazy. I know IIRA and Immigrants List, they are advocating for statute of limitation type things on all of the inadmissibility provisions.
Yeah.
And maybe the removability ones too. I mean, 212A9 is what they've got their sights set on, but I don't know if they've got the votes. Who knows?
Well, we should mention, I got an email saying Immigrants List is doing their first conference as well. You got to plug these things, you work with IRA.
I don't work for Immigrants List. I didn't even know about their conference until just now. And I know what they're doing a lot, but I was not aware of Immigrants List conference.
I got an email saying Immigrants List is doing its first conference, something like that. IRA essentially has IRA's like thing, or I mean, he's part of it generally.
There's a whole team, and it was he birthed it with other people, and he's very involved in it. But I mean, at this point, they've got lobbyists, individuals in DC who do this as their living, like any other political action committee. And it's also Sui Chung is on the board, and Michelle Canero, I believe, and a variety of other individuals. It's definitely a group project, but of course, IRA and our firm are very involved in Immigrants List. I support them. It's the only real political action committee advocating for immigration reform that's fair for non-citizens. And you've got, to use a bad word, you've got FAIR on the other side lobbying strongly for these policies that would really harm non-citizens. You think it's bad now. If FAIR had their way, you would have a really draconian immigration framework. And so I'm very pro Immigrants List. I mean, IRA's been around forever. He knows this stuff better than anyone. And he came to the conclusion in the early 2000s that, quite frankly, we're all just arguing around the margins until there is significant reform to reel back IIRIRA from 97. That is how you really do this. Everything else is games and helping people at the margins. And so if IRA came to that conclusion,
he's right. I mean, for those who are familiar, IIRIRA is the 1996 rule that President Clinton signed in, and it created the 3 to 10 year bar, the permanent bar. It's just really, a lot of other things, amongst other things. Yeah, they got to ease up on that stuff. The waiver, 601 waiver, the whole system. I despise waivers because I think it's such a stupid system they create that I don't want to do them. But it's like you got to do them, and so but it's just like extreme harsh standards, such a mess.
I mean, that's the thing. I mean, Bolinas Lucero, and I don't know if the 101A. Yeah, I do know 101A48, the definition of a conviction under immigration law, is amended with IIRIRA to, in part, change a non-citizen favorable BIA decision, matter of Ozark. So that's an IIRIRA thing. This whole thing, Bolinas Lucero, and the immigration judge is correct. And this could change with immigration reform. The immigration judge essentially says, sir, I understand. I believe you. There's nothing I can do. I'm not allowed to look behind your criminal conviction, even if I believe that this was all a mistake. The immigration judge is right. They're not. Cancellation of removal, which is what he was applying for, non-LPR cancellation of removal, that used to be a suspension. Yeah. And this high standard that I always talk about on the podcast, exceptional, extremely unusual hardship. I mean, what the hell does that mean?
Yeah.
It used to just be extreme hardship. I believe it was extreme hardship. It might have even been lower with suspension. 212C relief, that was taken away by IIRIRA. I don't think we as a country, when push comes to shove, when you know the non-citizen, maybe in the abstract, I don't think we as a country, I could be wrong, the majority wants this country to really not permit long-term people who have lived here for a long time with U.S. citizen children to leave based on, but when you take away suspension, when you take away 212C, both of those things were essentially second chances, giving an immigration judge discretion to say, you know what, you've become a good person. I'm not going to judge you based on the worst thing you've ever done. The rest of your life shows that you're a good person. I'm going to give you a second chance. All of that was taken away with IIRIRA, and now we have non-LPR cancellation of removal, which can be very under the statute. It's very hard to get.
Yeah.
So I don't know if we have as a country. I know that non-immigration attorneys don't know about that. I think that if you ask them, they would say, yeah, I mean, non-citizens can get a second chance if they deserve it. And that's not really the case anymore. And so that's what Immigrants List does.
I've had people who are like anti-immigrant call me that say, yeah, I don't believe this stuff, but I have this one person who's different.
Right, everyone's got this one guy.
Yeah. And they knew the facts behind who's getting crushed on this waiver stuff, this cancellation stuff, and like how it actually works. Like what we see, it's like how ridiculous some of these procedures are and stuff. I think majority of the country, like from my just talking to everybody that I talk with, would be like, yeah, that doesn't make any sense. But
right.
I think probably telling the story is the best thing for people to make the switch.
I used to work for an immigration judge who's since retired, who would tell me, like, before matter of ARCG, which was the case that says domestic violence can be, to paraphrase, domestic violence can be a path to asylum. Before ARCG, which was then vacated by matter of AB, but now it's back because of Attorney General Garland. Before ARCG, these predominantly women would come into court and they'd give them a 3-hour hearing and they'd be up there talking about the horrible rape and abuse and beatings that they suffered in El Salvador or Guatemala or whatever. And, all the machismo, all the things that you put into a domestic violence case, if the country condition evidence supports it. And he'd have to look at them and he'd say, usually ma'am, I believe you. What you're telling me is terrible. There is no precedent that permits me to grant your case, whether in the Ninth Circuit or at the BIA. Mm-hmm. And then they'd have to appeal it. I mean, the judges have to follow the law.
Yeah.
That's why it's so important that you have things where you have an attorney general and a BIA who, have a certain view of the law and that you advocate for immigration reform.